friends. We have a good friend, Godfrey Mwande, here. We're talking about immigration law. And particularly, we're talking about certain issues involving immigration law that are pertinent. And people want to know how they can possibly stop the removal proceedings, leave the country, and maybe come back on the business visa or some other kind of visa. In particular, I had people ask some questions, and we would like to respond to you. And thank you for sending your questions. I'm going to start reading this, and then we'll get into a conversation. How does getting voluntary departure help me return back to the United States? The presumption is that you're going to leave the United States, get a voluntary departure, leave, and then come back on some kind of visa. What do you want to say to this kind of person?
Well, voluntary departure is something that frees you from having a removal order that's going to buy you definitely from coming back for either 5 years, 10 years, or 20 years. Okay? Perfect scenario is this. A person has a pending asylum application. If it's a bona fide, that is, it's a good asylum, you do not accrue unlawful presence, which if you depart and you have 3 years, you have at least 180 days of unlawful presence, you're barred from re-entry for 3 years. If you have a year and longer of unlawful presence, you're barred for 10 years. So, as long as it's a good application, it's pending, you can go and come right back because you have no unlawful presence. So no bar.
So here's what I'd like you to know. We often litigate with USCIS, and they may count the bar against you, they may not count the bar against you. We file lawsuits to make sure that this is not counted against you. We file Mandamus action, and we can win that kind of a lawsuit. Not always, but we work very hard. And what you need to know is that you cannot be on a status to the point where you are barred from coming back to the United States. However, if you're not barred, let's say, for example, you filed for asylum while you were still in status. Let's say you did not accrue any illegal days in the U.S. You can potentially shut down your asylum case in court by getting voluntary departure and coming back. Let's talk about the mechanics of getting the voluntary departure. It used to be easier. It's not easy anymore.
Yes. And you can get, before the immigration judge takes testimony of anything on your application, and you could be pending, you don't have a final hearing yet, no testimony is taken, you walk into court and you say, Judge, I don't even want you to hear it, just give me voluntary departure. Judge can give you up to 120 days, which can be useful. Prepare to depart. At the end of the testimony, if you notice things didn't go very well, you can still ask before the judge hits the hammer saying, deport. You can still ask for voluntary departure, but only up to 60 days. Now, in both cases, you have to have good moral character, means no major criminal stuff. And also you have to demonstrate, if I give you voluntary departure, you have a valid passport, for example, you actually have the money to buy a ticket. And in most cases, if you know that's what you're going for, you go with the itinerary, showing your flight destination, etc.
So you're going to ask when and how. Here's what we do for clients in the scenario that we're talking about right now. We try to time your voluntary departure to the point where your other visa may be available. For example, if you're in a labor certification process and there will be a green card coming, if you have a potential to do an L1A later, if you are waiting for your EB2 visa and IW being approved, there's all kinds of circumstances. We don't necessarily want the voluntary departure immediately. We sometimes wait so that you can stay in the U.S. till the very final moment when your visa or your green card is available. Then you get the voluntary departure. You have 120 days to leave. You leave, get your appointment with the consulate processing, and come back. In fact, we now have attorneys in the office who have worked with consulate processing. They've been consular officers. they've been USCIS attorneys, and we try to understand the USCIS and the consular processing mentality by understanding what these attorneys have worked through so they can use their strategies now helping our clients get their consular processing done successfully and coming back to the United States. Make sense?
You raise a really important and really wonderful thing to talk about. If you have current process, for example, you're going for a Green-karta for employment, EB, you can take this all the way up to when you look at the chart and you know your visa will become available, and you can leave because if you have 120 days, you can plan it out. But when you go to the consulate, okay, they cannot talk about any of this other stuff. We're in deportation proceedings. They cannot. They will just look at one thing. Do you have any bars that are criminal, for example? Do you have any bars that are fraud? Did you commit any fraud? They can look at unlawful presence, but as we said, if you have a pending asylum application, don't accrue anything.
Right.
So you go out there, you consular process, and within months you're gone.
So this brings me to the next question, because I've positioned some of the client questions in a way that would help us discuss this. So how quickly can I come back to the United States after my voluntary departure? It's $1 million question if you're doing an EB-5 visa. But I'm kidding about the EB-5 visa. How quickly can you come back? Let's talk about that.
You can come back almost immediately. Say you have 120 days to depart. In 115 days, you're good for adjustment. You can exit if you have an appointment at the embassy, right, get your immigrant visa, and come back.
Right. So I want everyone to understand that lawyer talk, when a lawyer says it's almost immediate, it's not what you think is almost immediate. Sometimes almost immediate could be months, and then sometimes it's years. But it could be a short time. We're also dealing with potentially a waiver scenario. There may be a waiver. A waiver works best if they have family members who are U.S. citizens. Perhaps you've had children in the U.S. in the meantime, and this is a good reason for you to come back for the benefit and the welfare of your child. There could be many reasons why you can get a waiver to come back to the United States. Give us some examples.
Well, right now I'm dealing with a case where the individual has a biological father and the father who raised her, both living in the United States. The father, who's biological, had a stroke. They're not really father-daughter relationship because he didn't raise her, but he could file the I-130 that qualifies her to immigrate. And so the father who raised her, unfortunately for him, then had another major medical issue. So this young woman now can get a waiver because she gave the embassy a passport that had the wrong date of birth in it. And so technically that's called immigration fraud. Now she gets a waiver, which is a hardship waiver, under a section where you show a U.S. relative who's either a permanent resident who would suffer extreme hardship.
That's where it matters. A U.S. resident who will suffer hardship.
And that has to be taken into consideration. Now, at the beginning of this case, we filed all kinds of documents, medical records, etc., etc. They came back to us and said, can you get the doctor to clarify this? That's really easy if you know what you're doing, if you do it the right way.
It's only easy if you have more than 60 years of combined immigration experience. All right, I'm going to read the next question. I have a pending labor certification process, and I'm about 2 years away from potentially being approved for a green card. But I'm in immigration court. I entered the U.S. through CBP One. How can I leave and come back? A complex scenario.
there's two answers to that question. Okay, CBP One means you were in Mexico or in Canada, you went on the app, and you
No one's in Canada.
and you made an appointment for them to take your asylum application.
Yeah.
Okay, some people got paroled in for humanitarian reasons. Usually, it was a family that has minor kids in it, and the way you know which it is if you get the humanitarian, you can apply for a work permit when you're here.
Yes.
And the other group just get a conditional, which does not entitle you to those benefits. Okay? So if you get the one that entitles you to those benefits, you don't even have to leave. So if you want CBP One, were paroled for humanitarian reasons, you can adjust status without leaving. But if you got the other type, now's the time for voluntary departure, because you cannot adjust, you cannot get your green card here, but you can depart, and there's no removal order to bar you from coming back in.
So in that type of scenario, generally what we try to do is ask the judge for an extension. We've had scenarios where we would ask a judge to give us more time to qualify for a green card through a labor certification process, even if a person is in the actual removal proceedings. The individual hearing is coming up, but we ask the judge for more time, and we tell the judge, we're up front with the judge, and we tell the judge, hey, we're going to get a green card through another process. Give us more time. Don't make him have an individual hearing. Let us just adjust to something else. Okay. So I'm going to keep going through some of the questions. Can I still get my voluntary departure if I lost my asylum individual hearing, if I got an order of deportation, and I'm going to make an assumption that you have an appeal pending. If you don't have an appeal pending, it's a very serious problem after 30 days. But we're going to make an assumption that the appeal is pending. What do you want to tell this person?
Well, in such a case, it's almost always no. Let me explain why. Because once the gavel, the judge's hammer, goes down and said deported, voluntary departure is not an issue. Every once in a while, the board will extend, if the judge both order removal, grant voluntary departure, extend the voluntary departure. Let me give you a scenario. You are given 30 days. Don't depart within 30 days. Okay? You appeal to the board. At the end of it, the board can extend the voluntary departure if you did not depart. Okay? They do it very rarely. I haven't seen it lately. So the key is before the removal order is in place, if you intend to go and come back, I think that's the time to take voluntary departure.
So the key is that you need to get a consultation with an attorney. I'm not saying you necessarily have to call us, but you have to get a consultation. You're not going to get everything. You're not going to get all the strategies. But if there's one thing you take away from this, A, don't give up. B, don't do this on your own. Get professional advice and get advice from someone who knows what they're doing. Can I come back to the U.S. on an L1A visa with a deportation order? And a flip side, if there has not been a deportation order and there was a removal, a voluntary departure, I should say. So let's tackle this issue.
Okay. Whenever there's a deportation order, there's going to be, if you exit without that changing, a bar. Let's say it's expedited removal. You come in at the border.
Yes.
CBP just says we're deporting you. There's a 5-year bar. If you go through the hearing with the immigration judge, almost always, if you depart, it's a 10-year bar. If, on the other hand, there's more than once that you've been deported, it's going to be a 20-year bar. Okay? And so it depends on which it is. But technically, if you have an L1A, you should be able to come back if those other things are not an issue. Okay?
So just so you know, an L1A visa, we do quite a bit of that, is a visa where you own a company in the United States or you work for a company in the United States You're an executive in that company. We prefer L1A, where you are an executive, you're a president, you're a vice president, you're a majority shareholder manager, for example, and you also own a company either in your home country or some third country. And if you have management capacity, executive capacity in two companies, you can come back to the United States as a manager of your own company through a visa called L1A. Obviously, if you've been deported, it's more complicated. Hopefully, you're not deported and you get voluntary departure, and you're smart about how you position yourself and you leave beforehand if you cannot adjust within the United States. Generally, if you have an L1A visa, you're more likely going to have to leave and come back, but do not get to the point where you may get an order of removal. Try to get voluntary departure beforehand. It used to be that you could get voluntary departure quite easily before the current administration. It was called basically prosecutorial discretion. Now it's been removed. Now you got to go to the judge. Judge may or may not give it to you. Generally, they will if you make an argument good enough as to why you want it. You got to also deal with the prosecutor, but overall, it's doable, and so don't give up. I'm going to go through our last question. How can I get a green card as a U.S. visa applicant if I'm in deportation court? I'm going to make an assumption that you have an asylum claim, and a U visa is when you're a victim of a crime. Oftentimes people come to us and they run a convenience store or a liquor shop or they're Uber drivers and they get mugged. This happens quite often. And if they're available to testify and help the police in investigation, they make a police report, they can get a green card and eventually become a citizen of the United States through something called a U visa where you're a victim of a crime. Now, and you're asking a question, if I'm in deportation, what happens to my U visa? Can I still get a U visa?
Yes, you can. If, assuming you've cooperated with law enforcement or can't because you have information about the crime, and most victims do, even if it was a guy, it was in a mask or whatever you've told the cops, that's cooperation. That's number one. Number two is going to be there's some kind of injury. But if it is true you qualify for the U visa, when your application is approved or the petition is approved, then you're 3 years in that status before you can apply for adjustment. Now, then it depends on jurisdiction. Okay? Typically, if you're in removal proceedings, the immigration judge is the only one who can grant adjustment. Can they grant adjustment? Well, it depends on whether you enter lawfully or not. Now, if you did not enter lawfully and you would like to exit and come back quickly, now you're talking about will USCIS, the Office of Chief Counsel, will they agree, which is called prosecutorial discretion, to terminate proceedings and give you voluntary departure, and you can go and come back without a removal order and over your name.
And there's also circumstances where you do a waiver. Now, for U visa, court aside, one of the primary issues you want to be aware of. If you're a U visa applicant, the police calls you on the phone, they want to ask you anything. Do not hide, but respond. If you don't respond to the police, your U visa is terminated because you're not cooperating. Cooperating does not mean you have to work for the police. It just means that you have to give them the information they're asking for. It doesn't mean you have to, wear a microphone and give them information about other cases. It doesn't make you an informant. You just have to cooperate in the sense that you have to tell them everything you know. If there's something you don't know, it doesn't mean you don't qualify for your visa. It just means that you don't know. The police can't get info from you that you don't have. You just have to be honest with them. If you have a description of a person, give them a description. If you don't have a description, you can still get a U visa. Just give them what you know. So this concludes today. We'll see you again. This is a nice exchange for your benefit so you can learn more about immigration law. Godfrey, always a pleasure.
Well, it was a pleasure, Yuri. Thank you very much.
All right.
Right.